So let's talk about some of the important things that must be contained in a tenancy agreement. Those vital clauses that a tenancy agreement must capture. Remember that it is the tenancy agreement that determines the relationship between the landlord and a tenant. It is only in the absence of a tenancy agreement that the law, the provisions of the law prevails. That is, what the law has already provided for will be assumed to govern the relationship between the landlord and the tenant. So number one, parties. A tenancy agreement must contain the parties. That is the name of the landlord and the tenant. And please mind you, if the tenant is a corporate entity, of course, some corporate entities would go to rent an office to use for their business. So the party there would be the name of the corporate entity. That is, if it is a company, the name of the company. If it is a business name, the name of the business name. That is, if they so wish, it is not compulsory. The CEO or the founder of the business may just choose to use his name. So he is at liberty to use his name. It does not matter. So the name of the parties must be captured in the tenancy agreement. Very, very important. Number two, description of the property. The property must be properly described. Yes, a detailed description. When I'm talking about a detailed description, I'm talking about the location must be captured, the type of property. Is it a mini flat? Is it a bungalow? Is it a 4-bedroom duplex? It must be a very detailed description, described in such a way that someone can easily identify that property. You don't have to leave any stone unturned when you are describing the property in a tenancy agreement. Yes, because I've seen a couple of times where in a tenancy matter in court, one of the excuses that the tenant may bring before the court is that, this process was not directed to my flat. It was not meant for me. That is because the property was not properly described, and as such, the process does not contain a proper description of the property. So this always causes some kind of issues, especially when there is any matter in court. Third on my list would be term of tenancy. The term of the tenancy must be stated. From which year to which year is it rented for? Is it 3 years? Is it 2 years? Yes, the tenancy agreement must capture that. Number 4, the rent amount. How much is it being rented for? Because that is the consideration. So the rent amount is also very, very important. It should not be left out. And then other fees. If there is any caution fee, security levy, and all those kind of fees, it should also be stated in the tenancy agreement that it has been paid. And if subsequently some of these fees would still be payable, the tenancy agreement should also state whose responsibility it would be to pay. And then the maintenance clause, that also is very, very important. When we're talking about maintenance, we're talking about repairs. Whose responsibility is it to repay this or that? Generally, we know that major repairs are the responsibility of the landlord, while the minor repairs are the responsibility of the tenant. But don't forget that when it has to do with the tenancy agreement, whoever that it's agreed that would take care of this, even if it is a major repair, and in that agreement it is stated that it is the tenant that will take care of that, please just understand that that agreement would bind the tenant and nothing place. Another clause would be the use of the premises. What is this premises rented for? Is it for residential purpose or is it for commercial purpose? This is another very, very important clause that a tenancy agreement must capture, because most tenants would rent a property for a certain purpose, and when they move in, they begin to use it for another purpose different from what they intended to use it for. So these are some of the challenges that landlords face. And if a tenant, after renting a property for a certain use, now uses it for a different purpose, the landlord has the liberty to evict such a tenant. Yes, but of course, you know, I always say the eviction must be done through the right process. Another clause that is very important would be, I would say, the pets clause. Are pets allowed in this premises? Is the tenant allowed to rear animals, pets, and the rest? Because I know that there are some people that cannot live without pets. Yes. So this is another very important clause that must be contained in a tenancy agreement to determine if a tenant has the liberty to bring in pets. Yes, of course, you know, if you bring in pets as a tenant and there is another tenant who does not like pets, it's going to be a problem. It's not going to be between you and the landlord again. Your landlord may be someone who likes pets, but a fellow tenant does not like pets or animal. You have seen a couple of cases like that. And then the last but not the least on my video today would be the subletting clause. I'm going to tag this video part 1 because this is quite voluminous. I'm going to do a part 2 of this video, but after this last point, I'm going to stop here. So the last point I will say is the subletting clause. Of course, you know what subletting is. So you rented an apartment, you are a tenant, and then now you let out maybe a part of the property to someone, and then you collect the rent. You as a tenant, you now collect the rent. So you are now making yourself a landlord in someone's house. Or maybe you don't want to live in the premises anymore. As you're moving out, you are handing it over to someone else. That is you subletting the property, which some landlords do not welcome, because the landlord must have trusted you but does not trust this person who is coming in. Okay, so it is always proper that you do not let the house to some other person. And I used to say that sometimes subletting is a big risk that most tenants take. You don't even know who is coming in. Even if you know the person, something may happen. And as long as your name, you are still the one who rented that apartment. The act of that tenant, the act of that subleasee, that's what we call such people in law, people who come and rent a house from a tenant. They are subleasees. So the act of that subleasee will bind you, because the landlord does not know that person. So you don't even know someone, or even if you know the person now comes in and something terrible happens in that house, you will be the one to be called upon, because the landlord does not know the subleasee. So this is one very, very important clause, because some landlords, they don't even want to hear stories, and it is even better that way. So if you've not subscribed to my channel, please do well to subscribe. This is Law Talks and Gist. If you're seeing my face for the first time, thank you for stopping by, and if you're a returning subscriber, you know I love you. Thank you for always showing your support. Please like, share, comments, and do not forget to turn on the notification bell so as to be notified each time there is an upload coming from me. At this point, I'm going to say thank you so much for watching. See you in my next video.